Okay, but thanks. Thank you, Dean Chemerinsky. Would you like me to do it, Robbie?
Um, oh, okay, we're going live.
Yeah, we're on.
We're live.
Yeah.
Okay. Good afternoon. Thank you all for joining us today. We are extraordinarily honored to have with us a very special guest, Dean Chemerinsky, the Dean of Berkeley Law School. I just wanted to mention that when we reached out to Dean Chemerinsky, he was incredibly gracious in accepting our invitation, and we really appreciate his time. We also want to thank Dean Mohamed, soon to be Interim Provost Mohamed, for taking his time. Every time we've reached out to him, he's been generous with his time as well. So thank you. I'm going to do a land acknowledgement, and then I'll formally introduce Dean Chemerinsky. We recognize that California State San Bernardino sits on the territory, and recognize that every member of the California State University San Bernardino community has benefited and continues to benefit from the use and occupation of this land since the institution's founding in 1965. Consistent with our values of community and diversity, we have a responsibility to acknowledge and make visible universities' San Bernardino more accountable to the needs of American and Indian and Indigenous peoples. I'll now introduce Dean Chemerinsky, our guest speaker. He became the 13th Dean of Berkeley Law in Distinguished Professor of Law. Prior to assuming this position, Dean and Distinguished Professor of Law and Raymond Pike Professor of First Amendment Law at the University of California School of Law. And Professor of Law and Political Science at Duke University from 2004 to 2008, and from 1983 to 1984, he was a professor at the University of California Law School, including as the Sidney M. Irma Law. He's the author of 14 books, including on constitutional law, criminal procedure.
Robbie, if I may interrupt, we are having a really difficult time hearing you because obviously your feed is bad. So why don't we just go ahead and have Dean Chemerinsky begin, and I think we'll be able to. He can maybe throw in some of his bio as we're talking, but actually we should have Dean Mohamed introduce Dean Chemerinsky, and but I just have to say to the whole world that I have been a fan of yours for probably 20 years now. So I hardly ever simper over guests, but this is the exception. Thank you so much.
Thank you. I feel well introduced. It's really an honor and a pleasure to get to be with you. Thank you so much for inviting me.
Can we have Dean Mohamed just say a couple of words, and then
Sure.
we can.
Sure. I'll fill in some of the gaps very quickly where the audio was cutting in and out. I think everybody got that Dean Chemerinsky is currently at Berkeley Law School. He's the 13th Dean at Berkeley Law, where he joined there in 2017. He's also a distinguished professor of law at Berkeley. Prior to that, he was at my alma mater, UC Irvine, as the founding dean of their law school, which I was bitter when that happened because it was after I left UCI, and I very happily would have attended UCI law, knowing that Dean Chemerinsky was there. He also held appointments at Duke, at DePaul, and at USC. He has authored 14 books, the most recent of which is Presumed Guilty, which I presume he will speak a little bit about today, but it's a wonderful book. Thank you, Robbie, for getting me a copy beforehand. where he discusses, as the subtitle suggests, how the Supreme Court empowered the police and subverted civil rights. In addition to his 14 books, he's also the author of over 200 law review articles. He was named a fellow at the American Academy of Arts and Sciences. In 2017, National Jurist magazine named him the most influential person in legal education in the United States. And in January 2021, he was named president-elect of the Association of American Law Schools. So without any further ado, welcome, Dean Chemerinsky. It is certainly an honor and a privilege to have you join us here today.
Dean Mohamed, thank you so much for that incredibly kind introduction. It was 30 years ago this week that a jury in Simi Valley acquitted the officers of beating Rodney King. A major disruption and unrest occurred throughout Los Angeles. I vividly remember it from having lived in Los Angeles. Not quite 2 years ago, after the tragic death of George Floyd, there was unrest in cities across the country. There were protests against police violence in literally all 50 states. The reality is there is a serious problem with regard to excess of police force in the United States. And there's a particularly egregious problem with regard to racialized policing in the United States. The statistics here are stunning. In 2016, Black males between 15 and 34 were 9 times more likely than other Americans to be killed by law enforcement officers. They were killed at 4 times the rate of young white men. Hispanic men are nearly twice as likely killed by police as white men. The United States Civil Rights Commission concluded that while people of color make up fewer than 38% of the population, they make up almost 63% of unarmed people killed by the police. My argument, and what I want to emphasize today, is the extent to which the United States Supreme Court is responsible for the problem of racialized policing in the United States. There are several constitutional provisions that are meant to control the police. The Fourth Amendment is meant to limit when the police can stop, frisk, search, arrest people. The Fifth Amendment privilege against self-incrimination is meant to limit police questioning and interrogation. The assurance of due process in the Constitution is meant to provide many safeguards, including when police conduct eyewitness identification procedures. Yet, for the first century of American history, there were no Supreme Court cases about these provisions. And throughout American history, the Supreme Court has interpreted these constitutional provisions not to limit the police, but to empower them. I begin my book with an example. It's a case that arose in Los Angeles. It involved Adolph Lyons. At the time, he was 24 years old. He's a Black man. He was stopped by Los Angeles police officers for having a burned out taillight. The officer ordered Lyons out of the car. The officer slammed Lyons' hands above his head under the roof of the car. Lyons complained that the keys that he was holding were cutting into the skin of his palm. The officer thought that Lyons was mouthing off, so the officer administered a chokehold on Lyons. The officer literally put his forearm around Lyons' neck and squeezed until Lyons was unconscious. Lyons awoke. He was spitting blood and dirt. He had urinated and defecated. The officer gave him a traffic ticket and let him go. Lyons did some research and he discovered to that point 16 people in Los Angeles, almost all like him, African-American men, had died from police use of the chokehold. Lyons sued the city for an injunction to stop the police from using the chokehold, except if necessary to protect the officer's life or safety. But the Supreme Court ruled that Lyons could not come to court to sue. To use the technical language, the court said Lyons lacked standing to seek an injunction. The Supreme Court said that Lyons could not show that he was personally likely to be choked again in the future by the police. The Supreme Court said, in order for a plaintiff like Lyons to seek an injunction, the plaintiff has to show a likelihood of future personal injury. Of course, no one ever could demonstrate this. No one can show that he or she is likely to be the one stopped and choked by the police, even if there's a policy that authorizes this. This case makes it very difficult and often impossible to sue the police for injunctive relief to try to reform police practices. If the Supreme Court had ruled in favor of Lyons, if the Supreme Court held back in 1982 that the chokehold is unconstitutional, then maybe Eric Garner, George Floyd, and so many others who've died would have their lives spared. The focus of my book is on how the Supreme Court has contributed to, and often largely contributed to, the problem of racialized policing in the United States. Let me give you two examples today. First, the Supreme Court has made it possible for the police to stop virtually any person at any time. Study after study shows that this power is used in a very racialized way. The story here can start with a case from 1968, Terry versus Ohio. A police officer in Cleveland was walking the sidewalks, and he saw two men on a public sidewalk across the street. And he said the two men were walking back and forth on the public sidewalk. Now, there's nothing illegal about being on a public sidewalk. There's nothing illegal about pacing on a public sidewalk. But the officer thought they were, quote, casing the joint. I don't think it's coincidental that the officer was white and the two men were black. The officer pushed the men into the store. The officer then frisked the men and found that they had guns they weren't allowed to possess. The men were arrested for illegal possession of the guns. They moved to keep the guns from coming in as evidence. The men said, the Constitution in the Fourth Amendment requires that the police have probable cause in order to seize somebody. There was no probable cause here that any crime had been committed. But the Supreme Court, in an 8-1 decision, ruled in favor of the police. Chief Justice Earl Warren, who we remember for writing the opinion in Brown versus Board of Education, wrote for the court in Terry versus Ohio. Liberal lion William Brennan was in the majority. Civil rights great Thurgood Marshall was in the majority. And the Supreme Court said that the police can stop somebody and frisk somebody without needing probable cause. All they need is, quote, reasonable suspicion. But the court didn't define reasonable suspicion. The most the court's ever said is it's more than a hunch and less than probable cause. But the ability of the police to stop and frisk is used in a highly racialized manner. Study was done in New York City, and it found that though people of color were 38% of the population, there were 63% of those stopped and frisked by the police. There have been studies done in Los Angeles, in San Francisco, in smaller cities like Greensboro, North Carolina, that show time and again, holding all else constant, people of color are much more likely stopped and frisked by the police. But let me give you another case that shows why it's not hyperbole for me to say the police can stop virtually anyone at any time. The case is Wren versus United States from 1996. Undercover police officers were driving in Washington, D.C. They said it was, quote, a high crime area. That, of course, is a euphemism for a community that's predominantly individuals of color. In DC, undercover police officers are not allowed by regulation to enforce traffic laws. But the undercover police officers followed the car. They saw a car stop at a stop sign, they thought 20 to 25 seconds. And they followed the car until the driver changed lanes without a turn signal. The officers pulled over the car, ordered the driver and the passenger out. The officers did a search of the driver and passenger area and found illegal drugs. Well, the defendants argued that the police pulling over the car for the traffic violation was just a pretext. What the police wanted all along was to search the car for drugs. The Supreme Court unanimously ruled in favor of the police. The court said if a police officer sees a traffic infraction, the officer can pull the car over, order the driver and passenger out, search that area of the car. The court said the underlying motive doesn't matter. Whether it's racially discriminatory doesn't matter. Think about it. A police officer told me as I was working on the book that if he followed any car for 15 minutes, he would see a traffic violation. The driver going a mile over the speed limit, changing lanes without a turn signal, not stopping long enough at the stop sign. And so this then means that the police really can stop any of us anytime. And we know that people of color are more likely to be stopped by the police. One more example with regard to the ability of police to stop and frisk any person anytime. It's a case called Illinois versus Wardlaw from 2000. William Wardlaw was walking on a sidewalk in Chicago. He saw 4 police cars in caravan fashion driving towards him. He decided to walk in the other direction. A police car that was driving and saw this pulls over and pulls Wardlaw to the side, stops Wardlaw, frisks Wardlaw. What was the basis for suspicion of Wardlaw? He walked the other way when he saw police cars coming. Wardlaw, in a bag he was holding, was found to have a gun that he wasn't allowed to possess. Well, Wardlaw said this was an illegal stop. There wasn't even reasonable suspicion, let alone probable cause. The Supreme Court ruled in favor of the police and said walking in the other direction from the police is enough basis for suspicion for the stop and frisk. But think about it. Wasn't it rational? Wouldn't it be rational for many young Black men when they see the police in a city like Chicago to just calmly walk the other way? Yet doing so, the Supreme Court said, is enough for reasonable suspicion to justify the stop and the frisk. My point with these examples, and I give many, is how much the Supreme Court has empowered the police to stop anyone at any time. The other example that I wanted to talk about is quite different, and it involves eyewitness identifications. Eyewitness identifications are very powerful evidence in court. When the victim of the crime says, I see who committed the crime, and that person is sitting over there, the jury is very likely to give great weight to that eyewitness identification. But we also know that eyewitness identifications are very flawed. The Innocence Project has done such terrific work in being able to exonerate individuals who were wrongly convicted. Often DNA evidence is found that shows that a person was wrongly convicted. In 70% of the instances where someone is wrongly convicted, there was an eyewitness identification, a flawed eyewitness identification. Social psychologists tell us that eyewitness identifications are often wrong. People have over a fleeting sense of the fleeting ability to see the suspect. They're under great stress. The lighting may be poor. Social psychologists especially tell us that cross-racial eyewitness identifications are particularly likely to be flawed. Yet, since 1986, and I picked that as the time when William Rehnquist became Chief Justice, through today, April 27th, 2022, in all of that time, there's only been one Supreme Court case dealing with eyewitness identifications, and that case ruled in favor of the police. The Supreme Court has allowed the police to conduct eyewitness identifications however they want, no matter how suggestive, and even no matter how unreliable. The court has failed to deal with this problem in any way at all. I have picked just a few cases and just a couple of examples, but I hope they help to show why I say the Supreme Court has contributed to the problem policing in the United States and racialized policing. The story I want to tell is very much one of how the Supreme Court has empowered the police and subverted civil rights.
Thank you very much, Dean Chemerinsky. That's you actually stepped on some of the things I was going to say with respect to. No, I mean, there's wonderful synopsis of, first of all, your book, but also just the past couple hundred years of the relationship between the courts and the police, and especially as it involves the rights and standing of people of color and other people in underrepresented communities. So if I could just for a second say some of the things I really loved about your book. And I've been, as Dr. Texera said, I've been a fan of your work for a long, long time, ever since I was in graduate school at UCI. So thank you for all your contributions to the field. One of the things, one of the things that I think was really novel about this book is just what you said, which is that you take the time to situate the court, and by the court, I mean the Supreme Court, at the center of the problem of police violence and racism. And you don't just do it by looking at the jurisprudence around police abuse cases. You actually widen the lens to look at the whole kind of array of race and law cases that, I mean, you don't identify all of them, but you take the time to talk about just the relationship between the court and questions of race and personhood over time. You draw a straight line from cases like Dred Scott to the Lyons case, which you mentioned, and Wren, which is one of what I think is one of the most important cases with respect to pretextual stops and stop and frisk and things like that. And you identify kind of the end of the Warren era in a manner of speaking with Terry v. Ohio. And that is a turning point in a doctrinal shift. And I think that, the way that you pulled all of these together to make the case, you're a lawyer, so you should be able to make the case. But the way that you pulled it all together to make the case, I thought was really just phenomenal. But you also take the time in a couple of chapters to really focus on the history of racist policing. And I think that's all that it can be called, from the days before we had municipal police forces. You talk about slave patrols, constables, watchmen, things like that. And then you bring it to the present when you're talking about, for example, you use the example of LAPD, not just under Daryl Gates, but the chief, whose name's escaping me at the moment, but Parker, was it? The chief prior to Gates, and with references to monkeys in the zoo, which reminded me of the Rodney King case, which you mentioned, where there were references to gorillas in the mist. And you also talk about the Rampart scandal and some of the abuses that came from there that were specifically targeted toward communities of color and people of color. And just a couple of other things before I get to some questions and then open it up to other questions. Just things I really loved about this book is you underscore the challenge of meaningful police reform and what I would call anti-racist policing practices absent judicial action that requires an adherence to the Bill of Rights. And I think one of the questions that I have, and I'll ask the question again in a second, but I think for the audience, it might be interesting for you just to kind of shed a little bit of light on the Bill of Rights and kind of what it means and how it became applicable to state police departments and things like that. But you write the court has failed in its fundamental duty to enforce the Constitution, and I think that's a pretty direct indictment, but I think it's fair, especially if you look at the cases as they've unfolded. And so I'll pause there with, I mean, I loved a lot about this book, but I guess I'll begin with the Bill of Rights question and just kind of toss that back to you for a second. And could you explain to those who haven't gone to law school or read the law that closely, kind of what the Bill of Rights is, what it does, how the particular amendments that speak to policing and how that got extended to the states, and kind of where you think the court should have gone about ensuring that they're applied fully to policing.
Thank you for the kind words on the book. When the Constitution was drafted it had very little to do with individual rights. Even though all of us might think that the Constitution is most important for the liberties that it bestows, if you look at the text of the 7 articles of the Constitution, there's almost nothing there about individual rights. And when it went to the states to ratify the Constitution, a number of states said, we'll do so, but only on the condition that it be amended to include a statement of rights. And very quickly in 1791, 10 amendments were ratified that we refer to the Bill of Rights. And what's key is to think that these amendments is all about limiting government power. And they were focused on limiting federal government power. So everyone's familiar with freedom of speech under the First Amendment. There's a lot of discussion now about the Second Amendment right to bear arms. Well, the framers were very distrustful of government power. And that included what we would think of today as law enforcement power. So the Fourth Amendment says that the police can search or seize somebody, generally only if there's a warrant and probable cause. There's so many rights to protect criminal suspects and criminal defendants. I alluded to earlier, the privilege against self-incrimination, the due process protections. In the Sixth Amendment, it's all about trial rights, right to an attorney, right to confront one's accusers, right to a public trial, right to a jury trial. But what's interesting that you allude to, that for over a century in American history, all of the Bill of Rights was thought to apply just to the federal government. State and local governments were limited by state constitutions, but the First Amendment and free speech didn't limit what a state could do. The Fourth Amendment and search and seizure didn't limit what a local police department could do. But in the 20th century, and especially during the Warren Court from 1954 to 1969, the Supreme Court applied the Bill of Rights to the states. Let me make use a concrete example. The key remedy if police engage in an illegal search or arrest is the evidence that comes from it is excluded. It can't be used at trial. It's thought that this will deter the police from violating the Fourth Amendment. But it wasn't until 1961 in Mapp versus Ohio that the Supreme Court applied the exclusionary rule to state and local police. This fits my thesis of how for so long in American history, the Supreme Court made no effort at all to try to check or control police behavior.
Thank you very much. And we have a couple of questions in the chat. I have a lot more questions, but I'm not going to hog the platform. I will reserve the right to at least ask the last question, because I think I want to talk about how you conclude your book. But we have a question in the chat from Mike Chow, who's a professor of biology here, who writes, what recourse is there when the Supreme Court fails in their constitutional duty? By definition, they interpret the Constitution and they have lifelong appointments.
Realistically, the remedy is to turn to other levels and other branches of government for a solution. The justices have life tenure. That means unless they're impeached, the positions are theirs until they retire or die. We have a very conservative court now whose justices have failed to recognize that the police abuse, racialized policing is even a problem. So the recourse has to be to look elsewhere. Many local governments, California state government, have prohibited police use of the chokehold. California adopted a law outlawing the chokehold after the death of George Floyd. Many local police departments have done so. That's one example. State courts can interpret state constitutions, provide more protection of rights than the US Constitution. A number of state Supreme Courts have said if a police stop is pretextual, then the evidence gained has to be excluded, taking a different approach than Wren. A number of state Supreme Courts have said that if an eyewitness identification is suggestive, then it can't come in court. So we can look to states to try to provide protection where the Supreme Court doesn't. We can look to the political process. national and state, to provide protection where the Supreme Court doesn't. But there's not much we can do if the Supreme Court doesn't understand the problem or is unwilling to deal with it in terms of the Supreme Court itself.
Thank you for that. And I kind of have a follow-up, but Dia Poole, who is a friend of the university and a servant of the state of California for sure, writes, I think her question is a nice extension of what you just said. So she writes, do you anticipate that the addition of Judge Jackson to the Supreme Court will bring new perspectives on this issue? Can and should Congress and state legislatures do more, since the Supreme Court has not helped preserve citizens' rights? And what would you like to see happen in the legislative branches?
Let me break that down into 3 questions.
Yeah.
The first question is about Justice Jackson. And my answer is no and yes, which I think a typical law professor answer. The no part of it is, it's still a court that's going to be 6-3 ideologically divided along conservative lines. There's still Chief Justice Roberts, Justice Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, who've shown no awareness of the problem of police violence, no awareness of the problem of racialized policing. So replacing Justice Breyer with Justice Jackson isn't likely to change that. But there's a yes part. Justice Breyer is often sided with the conservatives in policing cases. There was an issue before the Supreme Court several years ago, a case called Maryland versus King, where the police can take DNA from a suspect to see if it matches DNA in a police database for other crimes. And it was Breyer with 4 conservatives who comprised the majority. Or there's a case called Navarrete versus California that involved whether police can pull over a motorist based on an anonymous tip of erratic driving, where the police should have to observe the erratic driving. The Supreme Court 5-4 ruled in favor of police, with Justice Breyer joining 4 of the conservatives. In both of those cases, conservative Justice Scalia joined the liberal justices. So I think Justice Jackson will be different in policing issues than Justice Breyer had been. But I also think that Justice Jackson brings different experiences than have ever been on the court. She's the first justice in history to ever have been a public defender. She's the first Black woman to serve on the court. And those experiences might influence the other justices as they decide policing issues. Several of the justices spoke powerfully, but when Thurgood Marshall came on the court, they learned things that they hadn't seen in their own experience. Justice talked about when Sandra Day O'Connor came on the court, hearing her experiences influenced them. I think having a Black woman on the court, a Black woman who is a public defender, might influence the justices in some of the cases involving policing. I just don't want to overstate that. Second, in terms of state legislatures, local governments, they can impose so many reforms in policing. Let me give an example. According to the Supreme Court, police can use deadly force so long as it's, quote, reasonable in the eyes of the officers at the time they do so. California passed a law that said police can use deadly force only if it's necessary. And I think that change is one that other states should adopt. Some cities, the 3 in North Carolina, have adopted their own laws that limit the ability of police to search based on consent, requiring that police inform people that there's the right to say no before they consent. And the number of consent searches has gone way down. Some local police departments, through their police commissions, through their cities, have outlawed the police from using no-knock warrants, where they come in the middle of the night without knocking their presence, knocking and announcing their presence. This is what led to the death of Breonna Taylor, where officers came in, they didn't knock and announce. The man who was there with her had no idea that it was the police. He picked up a gun, the police started shooting, killed somebody. These are examples of reforms that can come. In terms of what should happen, there's so much that can be done to change policing. A bill passed the House of Representatives after the death of George Floyd, and again this session, that would change the thing about police liability, such as the standard of qualified immunity. They would have outlawed police chokeholds. It would have instituted a very simple reform that would make a huge difference. require all police officers to record the race of those who they stop. We have seen just that decreases racial profiling. Unfortunately, that bill never got through the Senate. So there's the possibility of congressional reform for the whole country. But for now, we've got to look at the state and local level.
Thank you, Dr. Texera. I see your hand up. Go for it.
You obviously don't know the protocol, Dean Mohamed. The organizers get to ask also. I was just curious. You haven't mentioned qualified immunity, and that is a debate that's going on just about all over the United States, and it almost seems to give police carte blanche to do anything. So this qualified immunity, and piggybacking on what you just said about police reform, you have written several editorials. The latest one was about 2 weeks ago, in which you addressed the need for Los Angeles County to have some reforms because of the actions of Sheriff Villanueva. It's difficult for me to call him sheriff because he has acted unlike any sheriff I've seen in California anyway in a long time. Maybe Joe Arpaio, but not anything like we've had in California. So if you could address those two issues, both related, by the way. So thank you.
Let me start with qualified immunity. I certainly discuss it a great deal in the book. It's interesting. I've been teaching about qualified immunity for over 40 years, and I've always thought it was a relatively technical legal doctrine. And it's interesting now how much it's become part of the popular vocabulary. Whenever a government official is sued for money damages, the Supreme Court has said they always have an immunity defense. Now, that's not because it's written into any statute. It's obviously not in the Constitution. The Supreme Court has invented it. Some government officials have absolute immunity. Prosecutors for the prosecutorial acts, judges for the judicial acts, legislators for the legislative acts. Police officers, when they testify as witnesses, even if they commit perjury, can't be sued for money damages. They have absolute immunity. But all other officials who don't have absolute immunity have what's called qualified immunity. And the Supreme Court has said this means they can be held liable only if they violate clearly established law that every reasonable officer know. The court has said, and I quote, it has to be that it violates a right that's established beyond debate. Qualified immunity exists to protect, quote, all but the plainly incompetent officers. And in case after case, the Supreme Court has made clear that police officers, even when they use deadly force and kill someone, are protected by qualified immunity. Let me give you an example, because again, this all sounds so abstract. It's a case decided by the Supreme Court in October of 2021, a case called City of Tahlequah, Oklahoma versus Bond. A woman called the police that she felt threatened by her ex-husband. The police came. They found her ex-husband in a tool shed. The ex-husband reached on the shelf and picked up a hammer. The police said, put down the hammer. The man didn't, and the police shot and killed him. Now, the police weren't close enough to the man that the man could have hit him with the hammer. And they weren't even close enough that the man could have thrown the hammer, but the police shot and killed him. The estate sued the police for excessive force. The Federal Court of Appeals, the United States Court of Appeals for the 10th Circuit in Denver, found that it was excessive force and that the officer was not protected by qualified immunity. The United States Supreme Court unanimously reversed, and the Supreme Court said that the officer was protected by qualified immunity. The court said that there wasn't a prior case with sufficiently identical facts to hold the officer liable here. A study was done by Reuters 2 years ago. They won the Pulitzer Prize that talked about in federal courts of appeals, police abuse cases overwhelmingly come out in favor of the police based on qualified immunity. One of the legislative reforms we need from Congress is to change the law of qualified immunity. It's not based on the Constitution, so Congress could change it. You also mentioned in the second part of your question, the sheriff of Los Angeles County. I believe that it is essential that we have civilian oversight of police at all levels. Whether we're talking about the FBI or ICE at the federal level, or the California Highway Patrol, or the Los Angeles Police, the Los Angeles County Sheriff. There's to be meaningful civilian oversight and control. There's to be an effective disciplinary system. After all, as we know, police have the ability to use deadly force to kill people, to impose bodily injury. Unfortunately, we don't have meaningful civilian control over the sheriff of Los Angeles County. He's an elected official, and he believes the County Board of Supervisors has no oversight over him. And I think that Sheriff Villanueva has shown, as recently as yesterday, constant disregard for individual rights, even contempt with regard to individual rights. And so the op-ed you mentioned proposes that the Board of Supervisors put on the ballot a charter amendment for the county that would create civilian oversight and control of the sheriff. We've had a succession. When you think of Sherman Black, Lee Baca, who went to prison, Villanueva, of lawless sheriffs.
Thank you for that, and thank you for those great questions, Mary. Much obliged. So I'm looking at the clock, and it tells me that we have 3 minutes left of your time, which is not going to allow me to ask all the questions that I still am dying to ask you. But I'll go to the end, which is, a couple of times in the book, but certainly at the end of your book, you seem to, you refer to the summer of George Floyd as this potentially pivotal moment in our history, and you seem to strike a kind of more optimistic tone, where you write, you say, the intense attention to policing in the summer of 2020 offers hope that this is possible. And you're talking about perhaps someday another Warren Court will emerge that sees the need to protect people's rights and control police. Perhaps the breezes of justice will surprise us and shift in an unexpected direction. And I don't know if I'm misreading that as and I know you're not naively optimistic, but I think you do strike an optimistic tone. And so my question is, from the time that you finished writing this book to now, and what you have seen, for example, there was just that shooting, the horrible shooting in Grand Rapids. There was the positive twist in what just came out today with regard to the state of Minnesota and the Minneapolis Police Department and their finding. But where do you stand on that now? Do you still see this as a moment of potential shift, or do you think the status quo will prevail? Another point in the book, you talk about just kind of the circular, like symbolic reform. There was a consent decree, and now, and now we're all good kind of thing. So where are you now on this?
Sure. Let me apologize, as I had before we began, that we have a faculty meeting that starts at 12:15. As dean, I preside over it, and so that's the reason I'm leaving. And I've so enjoyed this, and hope there might be an opportunity to come back and continue this or have other conversations. Oh, I think the easiest way to answer your question is, I signed the contract to write this book in January of 2020, and I plan to take a year or two to do it, which, as you know, as dean and professor, that's common. And then the death of George Floyd tragically occurred in late May of 2020. And my editor got in touch with me and he said, how soon can you get me the manuscript? And we want to do it now. So I very quickly wrote the book over the summer and turned it in late October of 2020. And I admit that when I wrote the book, I felt optimistic. There were protests in all 50 states against police violence, and in the midst of COVID. It was the first time that we had sports events canceled because of police violence. And I thought, this is going to be the impetus. And quickly the House of Representatives passed a bill, and local governments were doing things. But now we're talking not quite 2 years later, and the impetus for reform seems to have temporarily lessened. There seems much more focus right now on the increase in crime than how we control the police. And so I admit I'm less optimistic for short-term reform than I was in October 2020 when I finished writing the book. But I believe that in the long term, there will be reforms. And I think it's so crucial that we focus on all of possible agents for change. We need to go to our local police commissions and local governments. We need to go to our state governments. We do need to pressure Congress. We do need to take things to the federal courts. We need to take things to the state courts. The more we push for reform and the more avenues we push for reform, the more likely we are to be successful. I worry, though, that it may take the death of the next George Floyd or the next beating of a Rodney King to mobilize action again.
Dean Chemerinsky, again, I can't thank you enough on behalf of all of us for taking this time. I know you have the faculty meeting to get
I'm
to.
gonna rush. And I hope you'll continue the conversation, and congratulations on your promotion. And I hope I'll have the chance to be with you again.
All right, thank you so much.
Thank you, Dean.
Thank you, Dean.
And thanks to Robbie for arranging all of this. This was wonderful, Robbie.
Yes, yes, absolutely.
Yeah.
All of you, to you, Mary, Robbie, Stan, Jeremy, everybody who's had a hand in keeping this conversation going over the past, gosh, it's approaching 2 years that, I just think it's remarkable. And this was not that we, necessarily guessed this way, but this was a great get. So
It
Yes.
was, yeah, very much so. And thank you, Dean Mohamed, for helming this entire thing today. It was quick, but I think we got some good information from him and some good questions. So it was wonderful.
absolutely. And I don't know if everybody who's still listening saw, but today the state of Minnesota completed or released the results of its investigation of the Minneapolis PD and found that they engage in a practice of racial discrimination. So they found it, a pattern, as Dean Chemerinsky was saying. Every investigation of racial bias in policing has found that they concluded that there was, in fact, before George Floyd, that contributed to George Floyd's murder, this pattern of racism in policing. So it'll be interesting to see how that plays out.
And to give us hope, I follow the LA Sheriff's Department as I alluded to in the question to Dean Chemerinsky. And several days ago, I think you read the Times, don't you, Dean Mohamed?
Yes.
LA Times. Several days ago, there was Sheriff Villanueva did a press conference, and he had a woman's picture on an easel during this press conference. And was it a kidnapper? Was it a murderer? No, it was a reporter. And he talked about prosecuting this reporter for something about her sources, an illegal source or something. And 2 days later, he backed down, which was in the newspaper today. He backed down because there was so much of an outcry from several different sources to not do this, because this gets us into, like totalitarianism and a bunch of other things. So I think, from that standpoint, your last question to Dean Chemerinsky about his hopefulness, and when I see things like that happen, and what we have seen on this panel, and I think Stan can probably attest to that there is hope, that there are people out there who are not quiet about what is going on in terms of policing and in terms of the criminal justice system itself. So I guess based on that, I just read this morning, I'm hopeful. Are you, Stan?
I am. I think the people that I admire the most and I'm hopeful the most are young people. The young lady up in Central California, in a place where she said, I don't know why I'm here and what I'm doing here. I'm in a college town, but she's fighting for the rights of people. And I think Zora, what was her name? Zora Lynn? It was on our.
Yes.
I was so proud of her. She's hungry.
One of our students.
She's looking so much forward to doing good things for people, and even Connie going to Berkeley I hope she gets accepted and can make changes. You know, one of the places, if I was going to be a lawyer, the place I'd want to be is Berkeley. I mean, that's the place to be. And so I wish her luck in her endeavors. But I think, yeah, I'm looking real forward to the future because so many young people are so hungry for change.
Mike Chow just put a question in the chat that I think is interesting, which is he's asking about the relationship between prosecutors and police and how that, and speculating that might hinder the accountability, right? I mean, ultimately, and I used to work as an investigator for the DC Public Defender Service. We were the investigators for the DC Public Defender Service. The police were the investigators for the prosecutors, right? So, which shows the imbalance right there, right? You got some guy who's 21 years old, you know, competing against the whole police force in terms of gathering evidence and things like that. But I do think that, you know, not to answer your question, Mike, but to just kind of say, I think it's a great question where that relationship, which is, you know, a codependent relationship in a lot of ways, if the police decide to stonewall and say, oh, you're going to prosecute one of us, well, we're just not going to give you the evidence that you need to get your, you know, 93% success rate or whatever the case is, it certainly does create a bit of a quandary. And so in thinking about legislative solutions, for example, something that would drive a distinct wall or create a wall between those two entities to ensure that police could be prosecuted for misconduct would be an interesting approach. I've never thought of that before. So thank you for bringing that up, Mike.
And you know, I think it is a great question, and I think it's actually more than the prosecutor, though. It's the crime lab, it's the CSI folks who come out. You know, they're all working for the same employer. You know, they're working for the county or the city or whatever. We see up in San Francisco, and there are a couple of other so-called progressive DAs who have recently been elected. And I'm thinking of Chessie, I think you pronounce his name Chessie Boudin, who is pretty progressive, very interesting background. His parents were in some underground group in the 1960s. But he has been fighting his own department. He has been fighting his fellow prosecutors. He's been fighting the police because he wants to bring reform to the city of San Francisco and maybe the county. I'm not sure. But yeah, it's a huge problem. It is a huge problem. The judges, you can have a police officer on the stand, what they used to call creative testimony. You know, where you sit up there and you lie. You actually lie on the stand, and there's very little pushback from the prosecuting attorneys. Very little pushback. The judge just, and you know the cop is lying. You know they're lying, but nevertheless, there is, you know, it's this thing where we all have to stick together, and I don't know how you solve that problem. Unless, as you said, you know, there's a wall there, you know, there has to be a wall between what happens in the prosecutor's office and what happens with police.
I sat in a deposition for 3 hours, and after 3 hours of giving the deposition, I realized that the case that I was reporting on was not the case that the deposition was on. So what I'm getting at is, so here's all this 3 hours of misinformation being passed back and forth to these lawyers and these subrogатors, and the bottom line is I finally tapped the city lawyer on the shoulder. I said, we need a break, and we went outside, and I said, hey, look, I said, the case that they're talking about is not the case that I'm talking about. I said, I know what case they're talking about now, but for the last 3 hours, I thought it was this other case that I brought my paperwork in for. Anyway, bottom line is, he said, let's not say anything. Let's continue on the same case you're working on and see what happens. So we go in there, we finish off in 4 hours, and he says, Stan, he said, I need to make a statement. The address Stan is talking about is not the address you guys are dealing with. And he said, I'm amazed that nobody at this panel, there's 12 people sitting around this table. Nobody recognized it.
Oh my goodness.
In the 4 hours. And you know what
you
they
did
said?
you did this as an official of the fire department.
An
staff?
arson investigator.
Arson
It was,
investigation.
yeah, and it was subrogation for the damages and so on and so on.
Mhm.
But the bottom line is they sat there. And so if that could happen for me, just think of all the other cases
Mhm.
that misidentification, misinformation, and so many other things could go on. And that's what the dean was talking about. He was saying that, you know, we go into and we believe that what we're saying is right, and maybe it's not.
Mhm.
Yeah.
It's true.
You know, I think one of the things I was going to ask him, and this will be my, I guess, my last point, but one of the things I was going to ask him about, if time permitted, was about, kind of the court's position in terms of separation of powers. And it's supposed to be this third co-equal branch of government. But, as I used to say when I taught law and society, they don't have an army or the power of arrest, and they don't control the purse strings, right? So they can issue rulings, but if the executive, for example, or Congress kind of ignores the rulings, then the court has no power for recourse. And I think one of the problems so essentially all the court has is its perceived legitimacy. And I think that one of the problems that the court faces, and this is not to excuse them at all for this kind of long history of ignoring police abuses or ensuring that the Bill of Rights be equally applied or adhered to. But one of the problems is that most people in our society don't see police racism, police abuse as a problem. And so and we saw this with the pushback against the Warren Court, which was the court over which Earl Warren presided as Chief Justice. When the vast majority of people in society err toward the kind of crime control side of the due process versus crime control equation, if the court goes too far in terms of ensuring adherence to the Bill of Rights and constricting the actions of police, not only will they lose their appearance of legitimacy for this vast majority of folks who never have to deal with this, right? Because it's not their lived existence. But then also they run the risk of being completely ignored by the chief executive and by the legislature. And that's happened a few times in the past. There was a famous case in the 1840s, which revolved around Native American sovereignty, where the court ruled one way, and Andrew Jackson was president at the time, and he's like, nah, never mind. and Congress did nothing either. So anyway, I was going to ask him his thoughts on that. But
Rafik, and it goes back to what he said. He said that probably not much change is going to happen until the next George Floyd.
Yeah.
And that's a sad state of account, but that's the truth until the next one comes around and people get up in arms and pushing and so on, because it sounds like the Supreme Court very much is supporting law enforcement and they really are doing it because they believe that crime is so important that they have to have as many rights as possible to do their job. But the truth of the matter is, if you look at all those cases he talked about, the obvious would be to overturn them, but they're not. It's just that simple. They're not. And so the next George Floyd may be the case that turns things around, but it's a sad commentary when you have to say that.
Yeah. When you have to have someone brutally murdered like that in front of the whole world.
In front of the whole world.
Yeah.
Exactly.
Well, thank you, Dean Mohamed. We appreciate your supporting us today, and we will definitely keep you on our list.
Well, great. It's always my pleasure to join y'all. And once again, thanks for this whole group. Thanks for all the work that you've done over the past couple of years to keep this conversation going. I really appreciate it.
Thank you.
Thank you, Dean.
And I do need to acknowledge Jeremy and Robbie and Finn. Finn has just been fantastic in terms of supporting us, and we could not do this without him. But Robbie and Jeremy also, and Connie. So thanks again, everyone.
Thank you.
I'll take care.
See you soon. Bye-bye.
Bye-bye.
I think we're meeting.